Hey everybody, welcome to the extended module of our practical HIPAA for therapist training. We wanted to do a 2026 update to kind of bring you up to speed on a few small changes, specifically a thing called 42 CFR Part 2. So we want to provide some clarity about what changed, who's affected, what you need to know, all that kind of stuff. I'm Ken Clark. I am the founder of Chenal Family Therapy. We're about a 200 staff person practice that does about 125,000 sessions a year. With me is Dr. Wade Fuqua, who is our chief clinical officer, our compliance guru. He's also the CEO over at Semi Private Practice. So this is the guy that keeps me out of lawsuits and jumpsuits. He'll be the one really kind of filling in the blanks for you. So Wade, I know not everyone not watching this, most people not watching this, they're not compliance professionals. They might have landed in this role. Why do they need to pay attention to regulatory changes like this?
Everyone does a HIPAA training every year or should be, and HIPAA is something that we're all attentive to. We at least all talk about. But what we have to consider is that our licenses, whether you're a counselor, MFT, social worker, doctor, whatever, has an expectation that you update and maintain your awareness of changes in, laws related to your practice, maintaining competence in your practice. And so something like changes related to HIPAA or 42 CFR, that is a compliance issue that we need to be up to date on. And it's also like some important legal stuff that we could get in, we could really get into some trouble with. Part of what I think we're seeing now, in 2026 and over the last couple of years is more HIPAA related fines and challenges and lawsuits and those types of things. So some very, foundational HIPAA knowledge with this on top of it, because most folks don't even really know what 42 CFR is, will really help make sure, you don't have to be at the level of compliance officer, but just that professional responsibility to keep yourself out of trouble, since you're working in this space.
So what is 42 CFR?
It's a federal regulation that adds some specific special privacy protections for SUD services, for SUD records. It's more stringent than HIPAA, and you may hear, people talk about, well, SUD records or they're at a higher standard than HIPAA, and that really is the case with what this is. More recently, there are some revisions that we'll talk about, but this really is covering SUD services, substance misuse services, any of those records and practices.
So there's a February deadline on this. Tell us about the February 2026 deadline.
Yeah, so for February 16th, 2026, there was a enforcement update. A law had been passed a while ago. I think it was actually back in 2024 that affected folks who were working in this space. So really it affected two groups of people. It affected Part 2 providers. We'll talk in a second kind of about what that looks like, but also lawful holders of SUD records, which is a little bit of a different concept most of us are not necessarily used to. But it affected either of those two groups of people. And so, if you're traditional, regular kind of covered entity, you may or may not be subject to this update. And so it's a little confusing. I think that's part of why we wanted to do this, and the origins of it is there's a lot of information out there, and honestly, folks don't really know what applies to them.
Yeah, so on the application side, is there a rule of thumb? Is there a litmus test to figure out are you a part two type provider?
Yeah, it's a great place to start. I mean, the traditional guidance and been in our previous trainings has been you will know if you're a part two provider because, well, you will have to have known that. That if you're providing SUD services, then you're most likely a part two provider, meaning covered under the 42 CFR Part 2. There's a couple of specific parts of that though. Kind of few more things that one, if you're receiving federal funding, which could include Medicaid, Medicare, or VA benefits as a part of your kind of funding in your practice. If you are holding yourself out as a provider of substance use disorder treatment, I think that's an interesting one, is that there are a lot of folks who are working and co-occurring, they'll work with mental health, but then if there's a substance use diagnosis that goes along with it, that may not necessarily qualify them as a Part 2, likely doesn't, even if they take Medicaid, because they're not holding themselves out as a Part 2 provider. So those are kind of the conditions under which you can kind of know whether or not you're a Part 2 provider. There's another element too that SAMHSA, the Substance Abuse Mental Health Services Administration of the U.S. government, does hold a list of who are Part 2 providers. A lot of states will as well. So you can kind of get a sense of who is a substance abuse treatment provider in your state. If you're not on that list, that probably means you're not a provider. But as we talk more, we'll kind of learn that you might need to be a little more attentive even without that.
So lawful holder, this reminds me of being in grad school and things like privilege, right? Like it was so
Mhm.
confusing what we're actually talking about, who holds it, all that kind of stuff. So for the non-lawyers in the group, which is probably
Mhm.
all of us, what is
Mhm.
a lawful holder?
Right. So I said it, who is this affecting? It's affecting Part 2 providers and then lawful holders of records. And so lawful holders is something that it is someone or some practice, some entity that has Part 2 records as a part of your medical records. And so, when you receive records in, that means that you're the lawful holder of that medical record. And so with this, there are prohibitions on redisclosing those. As soon as you begin to incorporate these records into your medical records, you become a lawful holder of those. And there may be some reasons why you don't want to keep it. I'll probably make the case that there's probably reasons why you do. But essentially, if things have been disclosed to you as a part of your healthcare practice that are SUD records, that makes you a lawful holder of those, and then subject to 42 CFR Part 2.
So you can be unaware of it and become a lawful holder if you're not careful. You don't have to be in the SUD business.
Yeah, and I think it's really tricky because for a lot of practices who are up and going and have been in practice for 10, 15 years, do you know what all records are inside of your medical record system? Probably not. You don't know 100%. And so I think you really have to be careful to think about to what extent this applies to you. Um, I think if it does, you need to distinguish what are your Part 2 records as a part of your medical records system. That you don't just want to have them kind of mingled in with everything, that you actually want to have some awareness around that, perhaps a designation on the file names of Part 2 record, because you handle them differently. You handle them differently for subpoenas, you handle them differently for operational pieces. So some folks may choose as we get into this as like, what are the implications? Like they may choose, well, this actually doesn't apply to us. And that's fine. Like we'll all make our own decisions about that. But it probably does if you have some of these in your charts.
Well, I think as clinicians, we've all probably been appropriately paranoid of subpoenas and court moments and stuff like that. There are practical implications here when it comes to things like subpoenas, right? So the notion that you just stick it in your EHR and we forget about it, but this could come up because our records person at our practice or
Mhm.
something gets a subpoena, correct?
Right. Yeah, absolutely. So, like, there are a lot of potential issues there. Whenever a subpoena comes up, we almost always have to challenge a Part 2 subpoena versus a traditional medical record. We know that based off of our HIPAA training, for example, it's a pretty high bar to not release those. We are the holder of the client's record under a traditional HIPAA lens. It's if there's a major safety risk, then we might be able to block it, but otherwise we really can't.
Practical planning. This is the practice owner in me. This also means probably increased legal costs for practices. If you're going to be challenging subpoenas and stuff, you
Sure.
probably don't want to do that without a lawyer in your corner, huh?
Yeah, absolutely. I mean, and the whole part of this is that with these, you do have to get pretty specific about them. And I would say they don't come super often because of the severity around like getting these records out there, like because of the extra barriers in place. But if it does, yeah, you end up having a lawyer you have to talk to.
So this creates some practical steps, I think, on inbound records. I think a lot of us are used to just adding records to the file or scanning them. Like we probably need to be looking when records come in. Are these Part Two records. I mean, what are the key things that we would use to spot one of these in the wild?
Yeah, I think there's a couple of there's an obvious thing that a lot of places will identify them as Part Two records. Like, it'll actually say on the top, as a part of that SUD records Part Two, special protections. There's usually some type of warning on there. That's a really solid practice that's adhering to that will have that disclosure to go along with it. On the off chance that that's not there, not obvious, or something of that nature, then you want to look at the source. We really should always do that whenever something comes in. We always want to look at where is this coming from. I think it's a good business practice to know where you're interacting with and kind of keeping track of that, whether it's referral relationships or not. But you would look out and see, is this place an SUD treatment provider? And that would be one potential kind of checkbox. And honestly, the easiest thing, if you're really unsure, is to call the provider and say, "Are you a Part Two provider?" They will know, and they will absolutely, be able to disclose that with you. And I think, it was interesting as I was talking to a lawyer about this. The conversation came up. She said, a lot of places aren't necessarily going to disclose Part Two records because they know that people don't necessarily know what to do with them. They don't want them to get out there. But there are plenty of cases where it can. So, it's like, well, you kind of need to be prepared just in case.
So, are there practical steps that people should be taking, like internal reference lists, workflows, et cetera? I mean, I know part of what you do is fractional compliance
Sure.
for other
Yeah.
companies. What are you recommending people implement internally around this?
I think the first thing is a good thing right now to check and see, is there a list that exists in your state? Looking at SAMHSA, that, sorting by your state to be aware of that, or maybe your closer entities that are related to you. I think it is important to build that internal referral or reference list. As you get things, you'll know, especially if you have to call and find out. I think also a lot of places, I mean, there is a strategic part here too of a lot of SUD treatment providers don't necessarily provide standalone mental health services. So there's actually a continuum of care conversation here that, separate from the privacy, where you want to. This could be a great opportunity for folks to build community relationships. So building that internal reference list is great. So if these come from here, I need to label them a certain kind of way. And I think the other part there is in those conversations, if you just get referred someone from a Part Two provider, an intensive outpatient that does, alcohol recovery treatment, they're most likely not going to send you SUD records. The referral itself is not a Part Two record. That would be healthcare operations, and we've talked about those types of things. So it's really very limited. It's more about the clinical content there. So they really wouldn't share those things without their own authorization. And continuity of care usually doesn't cover that part.
Yeah. That makes sense. So what about clients that you're treating, and part of your care is to talk about substance use and, as part of their mental health and their therapy. I mean, does that create Part Two type records when we're putting it in our clinical notes, et cetera?
Sure. Yeah, absolutely. Like come in treating depression, you learn someone has an opioid dependency that you have to treat or something like that, and you add that to the chart. If outpatient mental health counseling practices, whatever the language is we want to use there, if substance misuse is disclosed as a part of this, is not automatically creating us as a Part Two record. Again, I go back to kind of where we started, which is, are we holding ourselves out as an SUD provider? No, we're not. We're a outpatient mental health accredited practice, and so that's what our services are. Are we receiving federal funding for SUD treatment? No, we're receiving it for accredited outpatient mental health treatment programs. So I think if you're providing an integrated mental health approach, that's where the distinction is versus standalone. And when you become standalone is where it becomes more where it's Part Two records.
What about treating co-occurring disorders and that kind of stuff? I mean,
Yeah,
that's what
same thing.
you're talking
Like,
about there.
yeah, absolutely. It's kind of the same thing where you don't necessarily automatically become that Part Two provider. It really comes down to the nature of services. And I think what's curious is there are practices out there that are trying to, again, are they starting an intensive outpatient program? Are they starting different types of programs in a group practice or in a private practice. And it would really be based off the focus of what those services are. I think a key point that I always come back to with these in that uncertainty is, you have this general guidance of what's a Part 2 provider. If you're unsure, you always want to ask your local healthcare attorney. Like that's always the safe bet, or your malpractice insurance, because they would certainly have a vested interest in making sure you get it right. Um, but it's a different type of work if you're doing co-occurring than standalone SUD services.
So you're saying we shouldn't trust the local therapist Facebook forum to answer these questions for us?
Like that's where when this came around, it was just like question after question after question, and a lot of opinions. And yeah, you got to talk to a lawyer sometimes. But I think our strategy has always been like, I want to ask the lawyer the most specific question possible that's going to save me some money, but give me the most confidence. And this kind of helps us funnel things down to a more specific question.
So let's shift gears off 42 CFR. Tell me about the notice of privacy policies update that's required as well.
Yeah,
And
and that's kind of where this came together, where the mandate that came in February was to update your notice of privacy practice in support of this. And so um, when you look at some of the model language out there, and there is some that's published, and some EHRs have actually published some model language to use in their internal informed consent doc or notice of privacy practices, it really only it all says if applicable, because it's only updated if you're a Part 2 provider or if you're determining that you are a lawful holder. If you're not receiving or maintaining Part 2 records, then you don't necessarily need to update this. I think where a lot of practices are is if you're uncertain, to kind of go ahead a little bit there, then should we update this just to be safe? Like that's kind of where we were as a practice of, do we want to update? And for us, we chose to because of the large volume of clients that we have coming through. We haven't historically determined the status of Part 2 records, even though we don't likely have any. So we chose to update it. On the off chance that we do have it, it helps us add additional layer protection just in case.
it really can't backfire, I guess. I mean, it takes a little time, little money, whatever,
Yeah.
but the update doesn't obligate you to something that wasn't there before, probably, right? It just kind of covers you a bit.
Yeah, I mean that's kind of like where my risk management is all about, trying to assess it and not, but you can't really eliminate it. And so this to me is a very easy strategy to put in there. It shows you're maintaining regulatory engagement, you're keeping up to date with things, you're not, doing your paperwork one time and never changing it. So demonstrating an ongoing engagement is really important, I think, if issues ever come up. I think what's interesting too is like, even if you update your language, it doesn't mean you have to all of a sudden give a new notice to every client at your practice. There's not an expectation for that. You should have it on your website. It should be readily accessible and for your new people coming in. But it doesn't mean you have to do a complete overhaul of everyone signing paperwork and all that kind of stuff.
So I think probably one of the fears that keeps people from doing this is small practices, especially solo practices or small group practices. This is just another thing they got to foot the bill on.
Yeah.
But like we've seen a million times, people are out there asking for each other for these, can I see yours in the Facebook forums? But Health and Human Services, their Office of Civil Rights actually puts out templates that are
Yep.
pretty much a safe harbor. I mean, can you talk about that?
Yeah, so there's a couple of different things. They put them out in multiple languages as well, which is great if you're, to make them more accessible to your community. They're kind of in a question and answer format, pretty engaging. And of course, we'll have some uploaded as a part of this, but there's some model language to start with. You always want to look at it and see how it fits your practice, in particular respect to like your release of records policies, anything that's a part of your process needs to be explained in your notice of privacy practices, which is different than your informed consent. Of course, these are separate documents. But it's a great starting point to update specific to your practice. It's usually pretty simple updates related to, location information, just, different orienting information to your practice. It's very standard from one place to the other.
Hmm. Well, so release of information forms, right? ROIs, as we call them, or the HIPAA release. Are there practical implications on those forms? Do we need to look at updating those forms as well?
Yeah, so again, if you're a lawful holder maintaining part two, then probably yes, you want to update that. And it's really helpful to identify and specifically list SUD records on your release form. So that you would include a specific line where your clients can initial check that additional layer of kind of clarity and acknowledgement that I'm releasing my SUD records. It really helps ensure you have that proper authorization with things, helps identify these also for your staff, your records custodians, that they are intentionally, we are doing this just because of the historic tight nature of those processes.
So can you give us some practical examples of what would actually look different on the form because of this? I mean, how might your form change structurally? Is it a different form than we're used to?
Yeah, I mean, I love checkboxes on these things. It's really helpful to just like, it makes them more accessible for whenever I go do a survey for folks for accreditation. I'm always say like, make it the most accessible thing possible. So if it's progress notes, entire treatment record, treatment summary, substance use disorder treatment records would be a checkbox on there. That I think would be very obvious. I love the initial to go along with it. It just clearly demonstrates authorization there. Um, that when you're disclosing SUD counseling notes, that really, we want to probably have that on its own document and not combining with other things. Consent for that, again, it's additional layer of support and protection, and so pretty minor updates, but just clearly identifying what it is that you're releasing related to SUD.
Mm. So yeah, you kind of mentioned something there that brought up the concept of secondary releases, which may be a new concept to folks and is not something that just applies to this. We've had practice policy of no secondary releases. Explain what that is, what the risk is there, and how this change is kind of made that even more pertinent.
Yeah, so a secondary release policy is a great thing to have for a practice. So if I receive testing results or treatment records from somewhere else or whatever at our practice, based off this policy, if someone requests their whole medical record, I'm not going to send that portion that we received. They would go to that provider and receive that. So it means that I'm not going to pass along whatever I've received, that secondary release. That medical records for us would only be released of the what is our medical record there. It really is helpful in this case because it means even if you have part two records that are not yours, that you receive from somewhere else for some reason, then you would not release them because you don't do secondary release. So it covers it with the exception of any type of court order, which is going to be a big exception to any type of release situation. And when those things happen, that's kind of the limited times in which you have to bring in an attorney on a records request or something like that, because those are just much higher scrutiny. But it wouldn't go out for a regular release.
Well, and I think a lot of people don't think about just the layers of this. If you're seeing an individual and they bring in their couple's records, or I mean, there's so many situations where we can get people in our records that maybe aren't even the identified client, but I mean, it's just a mess. So,
Hmm. Hmm.
one of our mottos within our own practice is, you can always slow it down. When in doubt, don't. Pump the brakes on these things.
Hmm.
Get that advice from a lawyer, from a compliance person, inside,
Yep.
outside your company, whatever.
Yep.
So subpoenas, I think subpoenas are remain one of the panic mode moments in private practice, in mental health, all that kind of stuff. So what are we doing different with subpoenas around Part Two records?
I think it's your workflow is going to hold relatively true. And whenever a subpoena comes in, you always want to look at, is it the right person? Is it a valid, all of the things that we look at with a subpoena. And in this case, I'm not going to immediately call a lawyer. I'm just going to say, do we have part two records that are involved in this? If I don't have a secondary release, right, then that means that it's only our records that would be subject to that. And I know if I'm a part two provider because we've already decided that. And then you proceed relatively straightforward if you're not a part two provider. If for whatever reason you don't have a secondary release policy, you would then need to look, do you have any part two records in there? And so I would not immediately release. If I verify that, yes, I do have part two records, then I would call an attorney to attempt to quash that subpoena. because of the higher level of protection on SUD records there. So not every subpoena, but those that would specifically cover Part 2, you essentially really your duty is to try to eliminate those subpoenas whenever they come in. And that's kind of one of the higher regulatory burdens of an SUD program, quite honestly.
Well, and you've mentioned really trying to coordinate with the attorney that is issuing the subpoena. In part, we know this happens, right? The client goes in for whatever legal stuff. They just sign a blanket form. The attorneys request everything. I think there's a notion that attorneys know exactly what they're requesting and
Sure.
exactly what they're looking for, and they won't take any less than that. Tell me
Mhm.
about collaborating with attorneys on this, reaching out to them, telling them we got part two, et cetera.
Yeah, I mean, I think it's a great thing. Lawyers, judges, whatever, they hear all about mental health. They know there's mental health records out there. Clients don't necessarily understand that everything could be released. And so one of the big values for us at our practice, and I think that a lot of people would benefit from and can benefit from, is talk to your client. Hey, we've received this release. Are you comfortable with this? Yep, I'm fine with that. Or actually, no, I didn't know they're going to take the whole thing. Let me call my attorney. So the client calls. But us as a practice saying, hey, this has been requested. The attorneys are, tell me what you're needing, right? That collaborative conversation can help narrow the scope of this. And if we disclose, hey, these are part two records, then there's that potential to say, oh, we don't want that. What we're trying to determine is, fill in the blank of whatever it is that they're needing, what their treatment dates were, or what their billing records were. There may be a more narrow scope than the whole record. And that collaborative conversation can save you a ton of time before you even have to call your attorney.
And that aligns, you heard about it in the previous portion of this video, but the minimum necessary standard in general, even we
Mhm.
don't want to just blindly be releasing records. Like we need to figure
Mhm.
out what they're actually looking for, release the minimum necessary,
Mhm.
maybe even inform the client, like here, you
Mhm.
need to understand what's being released right now. So
Yeah, absolutely.
yeah. Let's bring this kind of back into the non-legal sense. Like a client
Mhm.
just wants their records, things like that. Some clients want that. They're moving out of state, or clients' right to review their records and all that kind of stuff. Are there practical steps around just a client requesting their records? If there's part two stuff in there, do we need to do anything different than before? If a client just wants a copy?
Yeah, so I think that falls similar to kind of how with HIPAA of what is the clients, what would benefit them. I think that, and with the higher level of scrutiny. So it's similar, but also again that higher level of like we wouldn't release these because we wouldn't disclose that. So I think it's again not to panic. Clients have the right to ask questions about their medical record. We as providers, and again covered in our HIPAA training, have a process and support to be able to respond with that. And there's 30-day timelines to those requests that we can go along with. So I don't think there's a reason to panic there. I think it's more about educating. Tell me what you're needing. Tell me what you're curious about. Asking specific questions in those situations has always been the way that we can get out of those and get in those situations more collaboratively without that essentially can eliminate a lot of needs for requests.
And it's worth throwing in there, right? I know a lot of people think of HIPAA violations in terms of information being accidentally released, but
Mhm.
the ostrich approach to this, burying your head in the sand when you get one of these and not releasing records, can also create a HIPAA violation, right? You can violate HIPAA by not releasing records in a timely fashion,
Mhm.
which surely happens because people are paralyzed by this, and
Yep.
maybe the client will just forget and stop asking.
Yep.
Don't bury your head in the sand, practically, right? Don't ignore records requests
Mhm.
either.
Absolutely. Yeah, there's an increasing number of fines related to people being reported for not, even if they responded in 35 days and not 30, right? Like there's a specific timeline there and there's higher scrutiny around that.
So bring it all back together, right? Let's
Mhm.
let's make this all actionable. That's what we're about at semi-private practice.
Mhm.
What should practices be doing now that the February deadline has passed? Like, what are the action steps?
Yeah, yeah. I think it's first right now determining are you a part two provider? And for many people in the mental health space, that will be no. And if the answer is no, then you want to look at okay, do I have any part two records in our system, or do we anticipate that based off programs we have or services we have? If no, then you might go to, do we want to include this just in case? With consultation with your attorney, the final answer may be no, because we don't anticipate any type of interaction with Part 2 records. If yes to any of the above, then you definitely need to make sure you update your notice of privacy practices. Either way, whatever decision you come to, if you choose to update, you'd want to make sure that it's sent out with your, new clients that are coming in, post it on your website, making sure that it's available for the public to review whenever they need to is something that a lot of folks will miss, and you want to make sure is up and available. And then updating your release if adding SUD as there if you believe you have those on your system or if you are a Part 2 provider.
Well, what about practices that right now that those action steps are easy, but they're also wanting to do intensive outpatient or
Yeah.
partner on, contracts with other providers, et cetera.
I think it goes back to consider the conditions under which you might be considered a Part 2 provider. If you are standalone, federally funded in some type of way, Part 2 provider that, hey, this is what we do, then there's a solid chance that you would do that. And you would need to have a higher, like a little more involved compliance framework related to records. I don't think that's a bad thing because, again, there is a lot of benefit to creating a space where folks feel safe for SUD treatment, um, because it can have major implications for employment and all types of situations, which is where these regulations have their origins from. But if you are going to provide more co-occurring situations and or services, you might not. Once you come to a decision, that's when I would get our opinion from an attorney. Hey, this is the program we're going to have. These are the types of records we're going to have. We believe we are not a Part 2 provider, yay or nay. That narrows it down to where you have that kind of safety net of an attorney signing off on it, but you're not that back and forth an hours long conversation or even longer than that.
This is huge. This simplifies so much. By the way, for those of you that, because I don't think we ever said it out loud, CFR stands for Code of Federal Regulations. So if you're
Right. Yeah.
wondering, by the way, like what CFR is,
The law.
right? So any other, that's kind of one of those obvious. I think a lot of people throw it out and they never, like they misspell HIPAA, right?
Yeah. Yeah.
HIPAA, guys, not two P's.
Uh-huh. Uh-huh.
So any final thoughts, misconceptions, anything else that you just want to stick a pin in and dog ear for us? Make
Yeah.
sure we go back and do this right.
I think a lot of folks are going to end up in the category of let me update it just in case. Like that's what we did as a practice. I think it felt like the most, again, it kept in line with communicating to the public that our practice is up to date, and actually the regulatory bodies that our practice is up to date with what's going on in the healthcare, laws and regulations. I think that's a great thing. Knowing a little bit of information, we don't have to panic. I think also as the dust settles on this, we have a little more clarity on this doesn't actually apply, but we want to be safe just in case. One thing that comes to mind about this one is because we're talking about laws and regulatory boards and whatnot is, you know, we may want to become a lawful holder of a record because we want to have that just in case. Anything, if you're ever accused of anything, if you ever have a board complaint, that medical record can become part of your defense. And I think that's an important thing to keep in mind, is if you receive some records and I don't need these, I might want to keep these just in case. That can become something that supports you and your healthcare operations response to that. So there's a lot of reasons to be aware of that and also know, okay, let me put a couple of things in place to move forward and then I can sleep a little bit better at night.
Well, and I'll tack on it. This applies to you, and you need to have a reasoned explanation, even if you decide that you're not
Hmm.
covered under Part Two. I think one of the biggest things we've seen over the years is regulators, auditors, whatever, they smell blood in the water when you look at them and say something like, what is Part Two? I mean, that talk about red
Hmm.
flags to dig deeper. So
Sure.
even if you don't think this applies to you, I think you need to be able to explain in a sentence or
Yeah.
two
Yeah.
why it doesn't.
Hmm.
Otherwise, you kind of got this neon arrow pointing at you saying these folks don't even know what the regulations are. What else is there? So
Yeah.
thanks for walking us through this way. And
Yeah.
I know this is a super complex topic. It's overwhelming for people. I think a lot of us a field like this are kind of paralyzed by regulations. So just to recap for everyone, tell me if I'm wrong here, Wade. Kind of the basic steps on this are number one, assess whether you're actually affected by these changes, right?
Mhm.
Number two, if you are, if you aren't, you need to have a good explanation on why. But if you are, you need to make informed decisions. You need to have a workflow about how you're going to handle Part Two records if you do receive them,
Mhm.
or even create them because of expanded services or something. And as always, you need to consult with an attorney, and not just a attorney, a healthcare attorney, a HIPAA attorney, not your friend who dropped out of law school,
Right.
if you're uncertain about these obligations. Is that a fair summary, Wade?
Absolutely. When in doubt, it's always safe to check with a healthcare attorney, not just like a labor attorney, not a HR attorney, a healthcare attorney. The HIPAA Part 2, like it is a very, very specific part of healthcare law as well. So I think each provider has a certain set of circumstances that they want to be attentive to and be aware of. And again, I think the whole theme for me with this too is that we need to be we need to kind of find a way to engage with compliance in these things in a way that makes sense and is safe and is not scary, and makes good decisions for our practice, to keep us out, kind of up to date with what's the latest and greatest of what's happening. So just a few simple things there.
Love it. As always, Wade, there's a reason why you have my back on this stuff as a practice leader, practice owner. I don't know many therapists that know this as well as you do. So thanks for everything. If somebody needs to reach out to you and ask you more about fractional compliance, or if they need referrals on attorneys or whatever, is there an easy way to shoot you an email?
Yeah, just Wade at semiprivatepractice.com is the quickest way to get to me, or drop it actually in the comments of this as well.
Okay, Wade at semi private practice. Thanks, Wade.
Yes, sir.